is Professor Christopher J. Robinette from Widener University Commonwealth Law School in Harrisburg, Pennsylvania, to discuss United Novelty Company versus Daniels, a case from Mississippi in 1949. Thank you, Professor Robinette. Tell us, what is this case about?
This case involved a 19-year-old employee, William Daniels, who was working for United Novelty Company, and they asked him to clean a coin-operated vending machine. And the vending machine was in a small 8x10 room, heated by a gas heater with open flame. And United Novelty knew that its employees liked to use gasoline to clean the vending machines, and they warned them not to because of the dangers. However, there was no evidence that Mr. Daniels himself had ever been warned. And so Mr. Daniels indeed was cleaning with gasoline. And while he was, apparently there was a rat under the vending machine that was soaking up all the fumes from the gasoline and decided to run to under the heater. And then, as the opinion states, he returned in haste and flames to its original hideout. And when it came back to the vending machine, the fumes there were so prevalent that the flame from his fur caused an explosion, and Mr. Daniels was killed. So his family members, primarily his parents, brought suit on his behalf in negligence against United Novelty Company. There was a jury verdict for the plaintiffs to recover, and then the defendant appealed, went up to the Mississippi Supreme Court, but the Mississippi Supreme Court affirmed in 1949, and so Mr. Daniels' family did recover.
All right. And why is this case important? Why do we care 50, 70 years later?
It's interesting, and it's in a way it's hard to tell why it's important because it's only been cited about 22 times, and that includes bar journals, law reviews, cases. It was not the first case to decide these particular principles. In fact, it cites other cases for the same principles. And I think it's important seems to emanate from the vividness of the facts. It's got a nickname, the Flaming Rat case. And it's just a very vivid image, and it perfectly encapsulates the proximate cause principle that it's known for, which is the unexpected manner of harm recovers.
Well, tell us about that. What does that mean?
So, I mean, really the legal issue in this case was, should United Novelty be responsible for the death of Mr. Daniels? And specifically, was United Novelty the cause of Daniels' death? In tort law generally, you've got to link a wrong to damage. And the wrong here was United Novelty putting poor Mr. Daniels in a room with an open flame, knowing employees like to use gas but not warning him. The damages are clear. Mr. Daniels is dead. And so the question is, can we link the wrong to the death? In tort law, that is usually done in two separate parts. There's cause and fact, and then there's proximate cause, or as the restatement third calls it, scope of liability. Cause and fact is basically mechanical causation, and the general rule is but for. But for the wrong of the defendant, would the plaintiff have been harmed? So in this case, if the defendant had not put Mr. Daniels in a room with lit flame, not warned him about using gas, would he have died? The jury concluded that no, it was the cause and fact, and of course they've got just the preponderance standard to deal with. And then so you also then have to add proximate cause. Most of the time, that's not a problem. Any cause that is the cause and fact is also the proximate cause. Proximate cause asks the question, under these unusual circumstances, is it really fair to hold the defendant responsible for the plaintiff's harm? And most of that boils down to foreseeability. Could the defendant have foreseen this? This particular case is famous for being the unexpected manner of harm type case.
Right.
And so the idea is it's the expected harm. It's the exact harm you would have expected, but it came about in a really unusual way. And the rule for that is if it's an unexpected manner case, the plaintiff still recovers.
Even though no one could have foreseen, in this case, the rat running around.
Exactly. And so when you think about it, if you ask United Novelty, what do you need to worry about if you stick an employee in a small room with a lit flame and you don't warn him not to use gas when you know employees like to use gas? The answer is they'd be worried about a fire or an explosion. That's exactly what happened here. And so the unexpected manner of harm doctrine prevents them from escaping liability for the exact harm they should have been aware of in the first place.
Now, why was this not a workers' compensation case?
So apparently Mississippi was the last state in the United States to adopt workers' compensation. They did that in 1948, but they did it after the facts of this case had already occurred. And so probably a year, if this had been a year or two earlier when they passed it, this case would never have arisen. They would have simply collected workers' comp and that would have been that. And
is this case still, is this something that law professors still teach law students?
Absolutely. It's in pretty much every torts case book that I know of. And it's also, you can see it on a lot of internet sites. When people are studying for the bar, they'll bring up the flaming rat case. And again, I think it's just so vivid that it sticks in people's minds. Like I said, 22 citations. Paul's graph's been cited over 5,000 times. So its influence, I believe, stems from this vividness.
Good. Well, thank you very much, Professor Christopher Robinette. This is very interesting. It's
Thank
a
you
pleasure
for having me.
talking with you. Thanks. Bye.